Good afternoon, everybody. My name is Michael Kandev. I'm with Davies in Montreal, and I'm happy to be your host this afternoon for the transfer pricing update session, which is the third session at today's first North American Region Conference. So first of all, I guess the important part for our US participants, the fifth code word for USA CLE is Cancun, C-A-N-C-U-N. Second of all, I would like to thank our sponsors. We have Duff & Phillips, a Kroll business, Ernst & Young, and Osler, Hoskin, and Harcourt. Quick introduction of our speakers. We have today Peter Macdonald of Osler in Ottawa. We have Lauren Ann Ross at Covington and Burling in Washington, D.C. And we have Harili Tsoukia, who's with Ernst & Young in Mexico City. So I will begin the presentation very briefly, then pass it on to Peter, and then we'll go on to a US update and finish up with the Mexico transfer pricing update. Please switch the slide, and again. So we had a budget recently in Canada on April 19th, and the budget had 3 transfer pricing related items. And I think this is a good place to start. First of all, the government confirmed its intention to proceed with the legislative proposals that were released on July 30th, 2019. I will come back to this in a second. Second of all, the government announced its intention to consult as a result of its loss before the Federal Court of Appeal in the Cameco case. Peter will deal with this extensively. Finally, and this was a bit buried in the budget, was a statement that implied that the government has now accepted the OECD transfer pricing guidelines developed in the context of the BEPS initiative. And that is despite the fact that Canada has previously hedged its position on this. So that's kind of an interesting point, but I will not comment more on it for now. Next slide, please. Going back to the first item, which is these legislative proposals that came out in 2019, they deal with a, I think, very interesting conceptual question, which is the following. In a complex tax system such as Canada's, where we have a general transfer pricing rule based on the arm's length principle, we also do have a number of rules in our system that could affect the pricing of dealings between non-arm's length parties. And that creates an interesting potential conflict, or at least overlap. Next slide, please. So for example, we have a series of rules, section 67, 68, 69, which deal with these type of situations. For example, section 67 says that deductions are limited to a reasonable amount. So reasonable is the standard that's used there. 69, which is well known, says that non-arm's length dispositions have to be priced at fair market value. So you can see that here we have the reasonableness standard, we have the fair market value standard, but these are not exactly the same notion as the one used in the transfer pricing rules, which is an arm's length transfer standard. So these rules were actually specifically dealt with, or at least are still currently dealt with, by section 247.8 of our transfer pricing rules, establishing a clear priority, in a sense, of the transfer pricing rules. But then you get into rules that are not necessarily completely dealt with. So for example, section 17, which deals with outbound loans, has an exemption in it, section 17.8, that is actually dealt with in the transfer pricing rules at 247.7. However, that is only a partial consideration of these rules, And if you're not in Section 17.8, well, you have a potential conflict between or overlap between Section 17 and the transfer pricing rules. And then you have other rules in the Income Tax Act that are completely not dealt with in the transfer pricing rules at 247, and that creates an interesting situation that has really not been dealt with in the past. So to resolve this, please switch slide. Thank you. The government has proposed now some amendments to our transfer pricing rules that set out a process of dealing with the transfer pricing rules, and which impose a three-step process, which you can see on your slide, where you start with identifying an initial amount, which the proposed amendment to Section 247.2 defines as the amount of the transaction after taking into account all provisions of the Income Tax Act other than the transfer pricing rule or the general anti-avoidance rule. Then adjust the initial amount in accordance with the transfer pricing rule in 247, and then use the adjusted amount when applying any other relevant rule in the Income Tax Act. So that's kind of interesting, and I wanted to just like set it out because of our North American audience, because it's just an interesting conceptual issue. And I'm just thinking, for example, in the US rules, how maybe there's an interaction between the AFR interest on outbound loans and 482 of the code. So these are kind of interesting questions that we've been asking ourselves and that our government wants to pursue based on the budget. I will stop at this with my introduction, and we'll pass it on to Peter, who will take on the remainder of the Canadian tax transfer pricing update. Next slide, please.
Thanks, Michael, and nice to speak with all of you. There is indeed a lot going on in Canada right now on the transfer pricing front, and there will be for the foreseeable future. We have important recent case law, proposed legislative amendments, and an upcoming consultation on the whole section. So Michael's talked a bit about the legislative provisions, and I want to start with the recent case law and look ahead to what's coming. And I'll start mentioning as background, particularly for our American and Mexican colleagues, that in Canada, our main transfer pricing provision has two parts. The first rule in paragraph 247.2a and c is typically referred to as the traditional transfer pricing rule, and it asks whether or not the terms and conditions of your transaction or series of transactions differ from those that would have been made between persons dealing at arm's length. This is our primary legislative embodiment of the arm's length principle, and it's the one that most people think of when they think of transfer pricing. Are the terms arm's length? If yes, carry on. If not, then you need to adjust the terms and conditions. But we also have an accompanying rule in paragraphs 247.2b and d, and they are typically referred to as the recharacterization rule. And they have two conditions for their application. The first is, in order for it to apply, the transaction would not have been entered into between persons dealing at arm's length. And secondly, the transaction can reasonably be considered not to have been entered into primarily for bona fide purposes other than to obtain a tax benefit. So it's worded in the negative, but it essentially asks whether the transaction was tax motivated. And we'll come back to what the rule is trying to get at in our discussion of Cameco. If we go to the next slide, just in terms of the landscape, our current transfer pricing provision was enacted in 1998, and it took a little while for cases to come to court. So while we have a number of decisions in the courts about the traditional transfer pricing rule, until the Cameco case, we did not have any jurisprudence on the recharacterization rule. And it's why, indeed, Cameco was such a closely watched case. Let's go to the next slide, which has a summary of the facts. Now, many of you might be familiar with the facts, so I'll try and summarize them relatively quickly. Cameco Corporation, the Canadian taxpayer, is the Canadian parent of a multinational company. It is a excuse me, a uranium company that mines uranium in northern Saskatchewan. And after a corporate reorganization in 1999, it entered into contracts to sell most of its production to a subsidiary in Switzerland, which we'll call Cameco Europe. And it did so under long-term agreements that had a mixture of pricing mechanisms, some that priced the uranium at the market price at the time of delivery, and some based on a fixed price established at the time the agreements were entered into. Cameco Europe also acquired uranium from Tenex and Urenco, which was treated as Russian uranium. And as an interesting side note, this was the uranium that became available as a result of Russian nuclear weapons being decommissioned. A whole fascinating story behind all of that, and some of the negotiations that led to this agreement are really quite interesting. Now, Cameco Europe took the uranium that it was acquiring, and it sold to third parties through a U.S. marketing entity labeled Cameco USA on the slide. And these contracts also had a mix of pricing mechanisms. Under a majority of the contracts, the uranium sold was priced at the time of delivery rather than setting a fixed price at the time the contract was entered into. Cameco Europe had a qualified board of directors. It had a very experienced president who was well known and respected in the uranium industry, but it didn't have more than one or two employees at any given time. It did, for day-to-day activities, logistical and back office activities, enter into services agreements, either locally with European firms, or, as noted on the slide, a services agreement that Cameco Europe had with Cameco Corporation that allowed Cameco Europe to meet its delivery obligations to clients. So the Canadian company was retained to provide those services. Now, after all these contracts had been entered into, the price of uranium spiked well beyond anybody's expectations. And as a result, Cameco Europe realized a very significant profit. Which certainly caught the CRA's eyes, and it reassessed Cameco Corporation to reallocate all of Cameco Europe's income back to Canada for a number of years. At trial before the Tax Court of Canada, the CRA argued three things. One, a common law sham doctrine argument. We won't get into it here. I have lots to say about it, but it's beyond our scope here. Suffice it to say that the court roundly rejected that particular argument of the Crown. But the two that do interest us for purposes of this session is the CRA arguing both the recharacterization rule and the traditional pricing rule. In fact, when Cameco was first reassessed, the CRA only reassessed on the basis of the traditional transfer pricing rule. But by the time we got to trial, the CRA had added the recharacterization rule, and it really becomes the focus of the decision, particularly at the Federal Court of Appeal. So if we go to the next slide, Cameco was entirely successful at the tax court, and the CRA appealed to our Federal Court of Appeal, where, as I mentioned, the CRA didn't pursue the sham doctrine any further. But at the Court of Appeal, it said the recharacterization rule applied, and the reason it said the recharacterization rule applied is because Cameco the CRA said, wouldn't enter into the same agreements that it in fact entered into with Cameco Europe. It wouldn't have entered into those with third parties, nor would it have let Cameco Europe pursue the opportunity to acquire the Russian uranium. And they also challenged the tax motivation conclusion that the tax court had reached with respect to the agreements as well. They also raised the traditional transfer pricing rule, but it really wasn't pursued vigorously by the Crown. The focus was really on the recharacterization issue. So if we go to the next slide, the key battle and the key, sort of the central part of the court's decision, focuses on what the proper scope of the recharacterization rule is. And the court asks itself whether the question is whether Cameco itself would not have entered into the transactions, or whether the question was whether no arm's length persons would have entered into the transactions. So the CRA was focusing on Cameco and whether it would have, whereas Cameco's submissions were that the test asked whether arm's length persons in general, can you say that nobody would have entered into those transactions? The court looked to the text that refers to persons dealing at arm's length, a more generic description of the test rather than a particular reference to the taxpayer or the particular taxpayer. So there was reason to believe that the use of the general suggested that legislators were referring to arm's length persons in general, not the peculiarities of the taxpayer. And the court found that it needed to be an objective test rather than a subjective test peculiar to the taxpayer. Next slide, please. So one of the key concerns that came out at the hearing for the Federal Court of Appeal, and it really plays in its decision as well, is this concern that anytime you had a corporation that wanted to carry on business through a foreign subsidiary, instead of entering into contracts with a third party, if the Crown was correct that you could say, well, you wouldn't have done it with a third party, then the first condition in the recharacterization rule would always be satisfied. And the court really found that unsatisfactory because in the court's view, there will be all kinds of situations when that arises, and that shouldn't necessarily satisfy the first condition. And the court posed that to the Crown over and over during the decision. And unfortunately for the Crown, they were never quite able to answer that. If we go to the next slide, the court, in terms of its context and purpose, it looked to the headings, technical notes, and the OECD guidelines. And we'll come back to the OECD guidelines and their discussion about when recharacterization is appropriate. But the takeaway is that the recharacterization rule is one that is focused on determining whether any arm's length persons would have entered into the transaction. And if the answer is yes, then it doesn't apply. Moving to the next slide, we've got, I've also got a slide there on the traditional transfer pricing rule. As I mentioned, it really wasn't the focus of the case, and ultimately the court said the Crown wasn't challenging any of the factual findings, and it wasn't going to step in and prefer one expert over the other. That's the job of a trial judge. Next slide. Agra City is a more recent decision of the tax court. It came out in August of 2020, and it's interesting in that it has some parallels to Cameco and relies on the reasoning in Cameco. And the CRA pursued the same three arguments as it did in Cameco. It raised sham, recharacterization, and the traditional pricing rule. And in Agra City, Farmers of North America was this group that sold memberships to farmers. And the case concerns an agricultural herbicide named called Clear Out. And the regulation of Clear Out in Canada meant that at the time, Clear Out could not be sold in Canada. However, as a result of the US Food and Drug Administration having registered the product, it was possible for a non-Canadian company to sell outside of Canada. And Canada had a program that allowed individuals to import products for their own use. So given that structure, the following was set up. New Ag Co. Inc. Was a Barbados company that was set up to acquire the product, and it was sold outside of Canada to the farmers, and the farmers would import it into Canada. Now, New Ag Co. Inc. hired Agra City under a services agreement and paid them an amount for dealing with all of the logistics of the importing of the Clear Out to the farmers that had purchased it from New Ag Co. If we go to the next slide. So like I said, the CRA argued all three arguments. The court didn't have a whole lot of time for the sham doctrine in this case either. And Agra City is interesting in that it raised recharacterization in the traditional transfer pricing rule, but I'm not sure how much it actually contributes to our overall understanding, partly because of the recent Cameco decision, which had already set out the court's views, but also because the Crown really suffered from a lack of evidence. So it found that there was no evidence presented by the Crown that would have suggested arm's length persons wouldn't have entered into the transactions. And similarly, the Crown didn't have sufficient or any evidence to support its traditional transfer pricing rule adjustment. So ultimately, it's helpful that the court seems to, at a minimum, require, especially with respect to the recharacterization rule, some kind of evidence, not just the say-so of the CRA that arm's length parties wouldn't have entered into the transactions. So let's go to the next slide and talk a little bit about what's ahead in transfer pricing in Canada. The CRA has been auditing inbound hybrid transactions, and I've put an example up on the screen. And this is a transaction where debt is issued, and for Canadian purposes, interest deductions are taken. But as a result of a couple of other agreements, for US purposes, the arrangement is treated as equity, and the interest payments are not included in net income in the US. And the CRA has been auditing and reassessing, or threatening to reassess, a number of other taxpayers on the basis that the arrangement would be recharacterized for Canadian purposes as equity, and therefore an interest deduction denied. The CRA hasn't yet announced how it intends to proceed with respect to these reassessments in light of the Cameco decision, but we would anticipate hearing about that in the relatively near future. If we go to the next slide. The budget announced a new audit tool for the CRA. And it actually is to legislatively overcome another Cameco decision dealing with oral interviews. Under our legislation, the Federal Court of Appeal found that the CRA didn't have the power to compel oral interviews from a taxpayer that the CRA had been pursuing. Now, under proposed legislation, the CRA will be given the power to require an owner, manager, or persons on the premises of a business to give all reasonable assistance and respond to all proper questions orally or in writing as required. If we go to the next slide, Michael mentioned this, that the Department of Finance has announced a review of the transfer pricing guidelines, the transfer pricing legislation, and that really will be interesting to see what comes up. It comes in the context of the CRA at the end of 2019 revoking its guidance that it had published in Information Circular 87-2R. So that was published at the time of the enactment of Section 247, and really gave the CRA's views on how Section 247 worked. And they had revoked that partly because of the new ordering rule that Michael referred to, and partly because they said that the recharacterization guidance from the OECD had changed over time. Now, query whether that's true. The OECD guidelines on recharacterization is still pretty narrow, and talks about only applying it in exceptional circumstances. But really, this legislative review and consultation paper will be interesting to see how the government defines the problem. So if we go to the next slide, you'll see a couple of quotes from the budget where the government refers to Cameco and says that it has highlighted concerns with the application of Canada's domestic transfer pricing rules, and that there's an inappropriate shifting of corporate income. The question really will be is, how does the government define the scope of the problem, what it views as the problem? Because at the end of the day, in both Cameco and Agra City, the courts found that the taxpayers were transacting on arm's length terms and conditions. And if parties are transacting at arm's length terms and conditions, isn't that exactly what our transfer pricing rules are intended to do? And the goal of the provisions has been satisfied. So we'll have to see what it is that what the CRA has in mind. Apparently, they do intend to cover both the recharacterization rule and the traditional pricing rule. And that's on the next slide. And so we'll see where this leaves us, and whether or not it brings into consideration any of the OECD BEPS changes and what accurate delineation of a transaction means. So lots to come in the future, and certainly something we'll be monitoring closely, and that you'll want to keep on top of, and potentially consider submissions to the Department of Finance. So with that, I will pass it off to Lauren for an update on the US.
Thanks, Peter. So the US transfer pricing update will have three parts. First, I'll give some general trends and talk a little bit about potential upcoming tax reform. Next, we'll have a case law update, which will itself have two parts. First, I'll talk about the Coca-Cola decision from last November. And then I'll talk about some cases in the pipeline, so to speak. And this second set is a set of cases that are currently under consideration by the tax court or other US courts. And the decisions should come out within the next year or two. So we can move on to the this slide, which is the big picture trend slide. So the first set of topics on this slide is just a general update about trends that I'm seeing in practice. The first bullet, COVID-19, is pretty self-explanatory. It's been on everyone's mind in the last year, including APMA's. And for those of you outside the US, APMA is the division at the IRS that's responsible for transfer pricing. APMA officials have mentioned in public comments that they're considering the effects of COVID-19, especially in their effects on existing APAs as well as APAs in negotiation. And in practice, we're seeing as standard course, APMA asking questions about COVID-19 in the due diligence stage of APA negotiations. The second bullet under the general update slide is the TCJA, or the 2017 tax reform. This was the first time that Section 482, which is the US's general transfer pricing rule, has been amended in many years. A new sentence was added to Section 482 that explicitly permits aggregate valuation of intangibles on the basis of a realistic alternative. So in practice, as we'll see during the case law update later, the IRS has been doing this for many years, even before explicit permission was added to the statute. The legislative history to the TCJA describes the new text in the statute as confirming authority to use aggregate valuation and not as a fundamental change to the law. It's unclear what weight, if any, courts will put on the legislative history and on the changes to Section 482 when considering transfer pricing valuation cases, including some that we'll talk about in the update later. So why mention the TCJA now? It's several years old. And the reason is because a lot of taxpayers are currently under audit for 2018, which is the first year that the TCJA rules are taking effect. The last bullet on this slide just mentions the interplay between US rules and OECD developments, which is something that Peter also discussed in the Canadian update. So in general, the BEPS-like principles from the OECD rules haven't actually been incorporated into the domestic Section 182 regulations, but we have anecdotally seen in practice the IRS sort of injecting these BEPS-like principles into audits, and we'll discuss this more when we get to the case law update, but I wanted to flag it up front. The middle topic of the update just mentions the Biden administration's focus on perceived income shifting. This has been in the news lately in the United States. Overall, the Biden administration continues to focus on Pillar 2 at the OECD talks. And then there's been discussion of changes to US tax legislation, potentially raising rates and implementing new measures that would make income shifting harder, or to try to ensure that profitable corporations are subject to tax. The final update topic is tied to the first two. And so there were temporary regulations back in 2015 that explicitly allowed for the aggregation of intercompany transactions under 482. These regulations were never finalized. They expired in 2018. One of the reasons that they weren't finalized was that the TCJA came along. So there was the IRS was busy finalizing a lot of other regulations, and the statutory changes to Section 482 that I mentioned earlier sort of eased the pressure on changing the regulations. However, a couple months ago, the IRS announced that that updating the Section 482 regulations is on the regulatory agenda. All right, so with that, let's shift focus and talk about the Coca-Cola case. We can move on to the next slide. So these days, you can't really have a US-focused transfer pricing presentation without at least mentioning Coca-Cola. It was a big tax court decision released last November, and it was a decisive win for the IRS, about a $10 billion adjustment, $3 billion tax in the 3 years under audit that the case covered. And Coke has announced that it does plan to appeal. And one of the reasons that this is an interesting case for tax practitioners is because it's a pure choice of method case that implements, just the most basic transfer pricing rules. What's the best method? How do we decide which transfer pricing method to use? A lot of other recent US tax cases have been focused on either obscure rules in the cost sharing area or more valuation cases. The main issue in Coca-Cola was whether the pricing of the license for Coke's core intangibles was at arm's length. So you see in the diagram, there's a little red circle over the transaction issue. This slide shows the product flow, basically. So Coke on the far left is the US parent. It owns valuable IP, like the Coca-Cola name, the formula, the famous formula itself. Coke then licenses this IP to the supply points that actually make the Coca-Cola concentrate. And the supply, that's the related party transactions, and the supply points include non-US subsidiaries. So the supply points then sell the concentrate to unrelated bottlers. So you notice the shift in the colors to represent that we're now moving from related transactions to unrelated transactions. And then the bottlers produce finished beverages and sell them to end customers. So we can move on to the next slide, which summarizes the transfer pricing positions. So the top of this slide shows the taxpayers method, which was a profit split. And this profit split was based on a closing agreement between Coke and the IRS for years, I think through 87 to 95. But the agreement didn't cover any years after 1995. However, Coke continued to apply it through the aughts. The IRS then challenged this method in the 2007 to 2009 cycle. So under Coke's method, the supply points received an operating profit of 10% of gross sales. And then the residual left over after that allocation was split 50-50 between the supply points and Coca-Cola in the US. So you'll see this referred to as the 10-50-50 method in some articles about Coke. The IRS contended that this wasn't arm's length because in the IRS's view, it overcompensated the supply points for functions. The IRS considered that the supply points really only performed routine functions. And so therefore the profit split wasn't an appropriate method. And so in the IRS's view, the parent was undercompensated for the use of the valuable intangibles that were produced and managed in the US. The bottom half of the slide shows the IRS's alternate method, which was the comparable profits method, which is the US equivalent to the TNMM. The IRS regarded the bottlers on the far right as comparable to the supply point subsidiaries because they were in the same industry, had similar economic risks, similar contractual relationships with the US parent, Coca-Cola, and that they employed many of the same customer-facing intangibles and ultimately shared the same income stream from the sales of Coke beverages. So in the IRS's method, the supply points had a return on assets that was based on the bottler's return on assets. And then all of the residual was allocated back to the US parent. Coke argued that the IRS erred in employing the CPM to reallocate income. Coke argued that the unrelated bottlers weren't comparable to the supply point subsidiaries because the supply point subsidiaries own valuable marketing intangibles that they were bringing to the table. So this case ultimately turned on that issue, whether the supply points held marketing IP that justified a higher return. So on the next slide, we'll look at some of the key facts that the tax court considered. We can flip to the, so the top half summarizes a handful of facts that the tax court looked at. It was a very fact-intensive opinion, 244 pages with 70 pages just of facts. But the tax court really honed in on the fact that the US parent, Coca-Cola, was principally responsible for consumer marketing rather than the supply points. Many supply points didn't have any staff themselves, and that local service companies and the unrelated bottlers, not the supply points, generally perform sales functions. So based on these facts, the tax courts found that the supply points did not have non-routine marketing IP. And so because they weren't bringing difficult to benchmark IP or making other non-routine contributions, the tax court found that the bottlers and supply points were ultimately similar and agreed with the IRS's position. And as I mentioned earlier, Coke has announced that it'll appeal the decision, so there will be more to come. The bottom of the slide has sort of the key takeaways for Coke, for now at least, as we wait an appeal, and how Coca-Cola might affect other, ongoing audits, as well as some of the other cases in the pipeline that we'll turn to next. So the first key takeaway bullet is that each year is a new cycle. In Coke, and in some of the other pipeline cases that we'll get to, the taxpayer and the IRS had some kind of either explicit or tacit settlement, and the taxpayer continued to apply that settlement to future years. And then eventually the IRS changed the agreed upon position to seek more tax, to allocate more income back to the US. And what's relevant here is that in Coke, the tax court gave basically no weight to the closing agreement from the 90s. First, the court noted that the closing agreement is a contract that just didn't apply to years after 95. The court also noted that the closing agreement didn't purport to represent an arm's length price. It was just a settlement agreement in effect, and that there were any factual underpinnings on which it was based, sort of however Coke and the IRS in the beginning arrived at the 10-50-50 split. Those factual underpinnings weren't actually memorialized in the agreement themselves. So the takeaway for practitioners here is to revisit old agreements, and that you can't just rely on them forever. So when negotiating new settlements, also consider buttoning them up to include the facts where possible. The second takeaway bullet is that the court really did a deep dive into the facts. In Medtronic, which we'll touch on later, the tax court reversed and remanded the circuit court reversed and remanded the tax court's decision on the basis that the tax court hadn't considered all of the facts underlying the comparability of potential cuts, basically. And so in Coca-Cola, the tax court really covered its basis. As I mentioned, the opinion's well over 200 pages. And here the tax court looked to the entity that actually conducted the marketing services, the services companies, and not the supply points. And they basically ignored how marketing costs were allocated through various intercompany recharges. And so this could be seen as being akin to the Dempey-like analysis under new OECD principles, although the tax court doesn't cite that OECD guidance or the BEPS rules. The final bullet just points out that the court took a common sense approach. We've seen the tax court do this in other cases by favoring comparable uncontrolled transactions when they're available, and by selecting the bottlers, entities with uncontrolled transactions at a different point in the same supply chain. This is a relatively practical approach again. So with that, we're going to turn to a case law update that talks about several cases under consideration. So there's 5 cases here. We're going to cover them quickly, just to basically flag for you so that you can keep an eye out for these decisions when they are released. So the first of these cases is Medtronic. I've already mentioned it a couple times. In many ways, it's pretty similar to Coca-Cola. Basically, the taxpayer applied a profit split based on a prior agreement with the IRS. The IRS argued that all of the residual should go back to the US under, a CPM. And then but there, unlike Coca-Cola, the tax court applied its own independent analysis and said that, hey, neither the CPM/TNM or a profit split is the best method. Instead, you have comparable uncontrolled transactions that you can adjust and use. The circuit court didn't reverse the decision, but instead vacated it and remanded it for further factual consideration. Specifically, the circuit court said that the tax court hadn't fully addressed whether the supposed comparable uncontrolled transactions were really comparable to the controlled transactions at issue. So we're now awaiting the tax court's opinion following the remand. So we can move on to the next slide and the next case. This is 3M, won't go into detail, but wanted to flag that this case is still out there. It's basically been sitting out there for over 5 years without much movement. But the Coca-Cola opinion did reference the pending 3M decision, so we know it's still active. So the basic issue in 3M is whether regulations are valid that allow the IRS, in most cases, to allocate so-called blocked income back to the US under the transfer pricing rules in Section 482. So this particular case involved royalty payments from Brazil to the United States, which weren't allowed to be paid under Brazilian law, and whether the IRS could still allocate that income back to the US parent. So let's move on to the next slide. So this mentions Perigo, which is a case that's in the district court in Michigan instead of the tax court. And Perigo shows, I think, one of the similar aspects to Agra City under Canadian law, which Peter talked about. And in that case, so in Perigo, the IRS used alternate arguments. So first, the IRS argued that an Israeli partnership that purchased drugs from an unrelated Israeli company and then sold them back to the US parent should be disregarded as a sham. And that was the IRS's primary argument here. And then in the alternate, the IRS has argued that the profits of the partnership should be reduced under Section 482. There were motions to try to get rid of the sham argument, the sham theory on the motions that did not go through, and so currently the courts in Michigan are considering both bases. And now we can flip to the last slide, which has 2 cases. These are both valuation cases. One is on the top of the slide is Facebook, which many of you may be familiar with. And then the other one is Western Digital. And there's similar cases in a lot of respects. Both involve the proper value placed on the outbound transfers of IP to Irish subsidiaries, either directly or in the context of a cost-sharing arrangement. So the basic point here is that valuation is hard. There's really no agreed on or standard methodology in the US for valuations. In both of these cases, the IRS argued that the income method or discounted cash flow analysis should be used, and the IRS came up with numbers, multiples larger than the values reported by the taxpayer. The IRS has looked at valuation in the past, including most recently in Amazon. A couple issues to note here before we wrap up. Unlike Amazon, the Facebook case is governed by newer cost-sharing regulations. Proposed in 2009 and finalized in 2011. And so, although the issues are similar in many respects, a different set of regulations apply. The second point to note goes back to the general update. Changes to the regulations, the TCJA amendments that we discussed that talk about aggregate valuation could come into play. It's unclear what weight the tax court will give that. Okay, so I know that we sped through these cases. I appreciate your patience, and I'd be glad to answer questions that you post to the chat later on when we get to the Q&A. So now we'll continue heading south with Mexico.
Thank you, Lauren. So let's move to the next slide, please. Thank you. And the main purpose of this presentation is to provide our audience with a big picture update on the Mexican government audit trends according to the President's master plan, and at the same time describe the facts around an ongoing transfer pricing dispute in the mining industry between the Mexican government and a very famous silver mine. Now, let's move to the next slide, please. Thank you, and the one after that. Thank you. Now, shortly after taking office, the president announced that his government will put an end to tax forgiveness. He pointed out that his predecessors granted around 20 billion pesos in tax exemptions, but he will adopt a tough approach, and under his administration, he will recover taxes from large taxpayers and warn tax evaders with criminal charges and imprisonment. Now, furthermore, he commented that from the universe of taxpayers who benefited from tax breaks, 58 of them are publicly listed companies. And the most important tax settlements made public over the past months were the ones of Walmart Mexico and Coca-Cola FEMSA, that is the bottling arm of the Coca-Cola business. And in total, they paid nearly 17 billion pesos, that is approximately 850 million US dollars. There were some other cases that were also made public, but famous of other multinational subsidiaries of multinational groups, such as IBM and Toyota. Now, the Tax Administration Service, the SAT, claims that the tax collection has increased in recent years, mainly due to audits, which now follow a different and more holistic approach, combining several factors like, for example, that the procedures they follow are being carried out more effectively, and that there is a greater coordination between the different areas. Now, this optimizes the use of tools, information, and resources. Now, keep in mind that the SAT is one of the most sophisticated administrations in the Americas as far as data analytics and technology is concerned. Now, next slide, please. Now, this is a Plan Maestro, the master plan. These initiatives are thoroughly described in the Mexican government's master plan, the Plan Maestro of the fourth transformation of Mexico, and are summarized in this slide that we have in front of us. I will not go through the details of the SAT's plan, but this graph gives us a pretty good idea of what the Mexican tax authorities are looking for following the instructions of the Mexican government and what their plan of action is. But to summarize what we have in front of us, we basically see that the Mexican tax authorities plan to schedule audits with a more assertive approach, and audits that will last a shorter period of time. They encourage self-correction and timely collection. They plan to eliminate the audit backlog, and they plan to reinforce the verification of the application of VAT credit balances. And with that in mind, shall we move to the next slide, please? Thank you. We expect to see a lot more audits focusing mainly on transfer pricing. One famous case that has quite an interesting history behind it, as a matter of fact, was made public and has still not been resolved, is the case of the San Dimas mine, and the company involved is Primero Empresa Minera. Now let's visit the history and the facts of the case. Shall we move to the next slide, please? In 2002, Wheaton River Minerals, that is a Canadian company, acquired the San Dimas property. Now, the San Dimas property is a mine in the northern part of Mexico, in Durango, that basically produces silver and, to a lower extent, gold. In 2004, affiliates of Gold Corp, Inc., that is another Canadian company, entered into the prior San Dimas agreement with Wheaton with regards to the San Dimas mine and two other mines in Mexico, but let's focus on the San Dimas mine. At that time, Gold Corp was selling to Wheaton through a foreign-based affiliate in the Cayman Islands. 1 year later, in 2005, Wheaton River merges with Gold Corp, and 5 years later, in August 2010, Primero Empresa Minera, which is a subsidiary of Primero Group, acquired the San Dimas mine from the Goldcorp subsidiaries. Now, when Primero acquired the San Dimas mine, the prior San Dimas stream agreement was amended and restated, and Primero assumed all of Goldcorp's obligation with regards to the Dimas silver mine concession. Shall we move to the next slide, please? Thank you. Now, according to the San Dimas stream agreement, it was stated that Primero shall sell to Wheaton 100% of the amount of silver that was produced in the San Dimas mine until it reaches 6 million ounces. And then 50% of the silver produced thereafter at the lower of one, the current market price, or $4.04 per ounce, with an annual increase of 1%. Now, that was defined as being the PEM realized price. And additionally, that agreement stated that Primero must sell silver through one of its non-Mexican subsidiaries to Wheaton Cayman subsidiary. Now, in order for the Primero non-Mexican subsidiary to be able to comply with its obligations under the prior San Dimas agreement that was that had signed, Primero Empresa Minera had to enter into an agreement, a new agreement that was named Internal Streaming Agreement, with the Primero non-Mexican subsidiary to supply it with the required amount of silver from the San Dimas mine. And now, what kind of intercompany pricing are we talking about in those cases? When Primero Empresa Minera initially acquired the San Dimas mine, the sales from Primero to the Primero non-Mexican subsidiary were made at a spot market price, whereas the sales from the Primero non-Mexican subsidiary to Goldcorp Cayman affiliate were contracted at the PEM realized price, which is what we initially mentioned in this slide. And at that time, that price, the PEM realized price, was $4.044 per ounce. In 2010, PEM, Primero Empresa Minera, amends the terms of sales to its Primero non-Mexican affiliate under the internal stream agreement and sold the amount of silver under the prior San Dimas agreement to the Primero non-Mexican subsidiary at the PEM realized price, which was the $4.04 per ounce. Now, for Mexican income purposes, Primero Empresa recognized its revenues on those silver sales at the value of the PEM realized price. Now, shall we move to the next slide, please? Thank you. In 2012, Primero applies for and receives a unilateral APA from the government of Mexico, confirming that the fair market value of the intercompany transaction was the $4.04 per ounce, the PEM realized price. That APA covered the years 2010 to 2015, but in 2010 to 2014. In 2015, the SAT initiated certain proceedings to nullify the APA, but we will discuss that later. On January 12, 2018, First Majestic and Primero Mining announced that they have entered into a definitive arrangement whereby First Majestic will acquire all of issued and outstanding common shares of Primero. And on May 2018, effectively First Majestic acquires control of Primero. And later that month, that year, the prior San Dimas stream agreement was terminated and another agreement was put in place for with First Majestic. Shall we move to the next slide, please? Thank you. Now, over the period of 2010 to 2014, PEM had a combined net earnings before taxes of $6.7 million US. We can see that in the table. That basically is calculated considering the PEM realized price. Shall we move to the next slide, please? Thank you. Now, as I mentioned, in 2015, the Mexican tax, there was an initiative to nullify the APA that was granted to Primero Mining, and tax assessments were made for the PEM results that we just saw in the previous slide, corresponding to 2010, 2011, and 2012 years. And it was calculated on the basis of market prices, not realized price, as we saw earlier. And the total amount of the reassessment included also penalties, surcharges, interest, and other accessories. Now, according to the government's analysis, well, basically according to the SAT's analysis, Primero set silver prices below market value. And for that, they used what they call a system that is similar to transfer values used by multinational companies to shift profits to low tax jurisdictions. And on the 12th of November 2020, First Majestic, that now is the ultimate owner of the whole group, announced that Primero Empresa Minera was provided with written reasons for the decision made on September 23, 2020 by the federal court. That was a decision that basically said that the APA had to be nullified, and that decision was based on stating that the SAT had errors when analyzing the request for the APA. And there was certain evidence that was not requested for purposes of granting the APA, and that the SAT failed to request from Primero Empresa Minera additional information before issuing the APA and confirming the PEM realized price value as being arm's length. Shall we move to the next slide, please? Thank you. Now, First Majestic was informed that PEM would be served with a decision dated on September 23, 2020 by the federal court, nullifying the APA that was granted to Primero and obliging the tax authority to re-examine the evidence based for the issuance of the APA based on the two reasons that I just mentioned. Primero recently received a notice to reassess fiscal year 2013 from the SAT and for recalculating Primero's taxable income on the basis of market prices instead of the realized price that we described previously for the silver sold under the intercompany agreement. The Mexican government calculated an assessment for those years of approximately $500 million US that is basically assessing the Canadian miner First Majestic. And what it says is tax debt stemming from non-arm's length prices over for the sales of silver over the past decade. Now, the federal court is expected to decide on the legality of that tax assessment. And to the next slide, please. Now, almost a year ago, First Majestic served the government of Mexico with the notice of intent to submit a claim under the provision of Chapter 11 of NAFTA. They had 90 days to come to an amicable negotiation to settle the case. That deadline expired. No resolution was made over the tax dispute. And more or less a month ago, First Majestic announced that it has submitted a request for arbitration to the International Center of Settlement of Investment Disputes. And it's expected to initiate the process under those rules. Next slide, please. Now, First Majestic, its position and what it claims is that the federal court's decision was not to nullify the APA, that is, was not based on regular procedures, and Primero Empresa Minera was not granted the opportunity to present evidence. The federal court's decision, it says it was flawed due to procedural irregularities and due to failure to address other relevant evidence. And therefore, with that in mind, shall we move to the next slide, please? It states that no tax is payable under the reassessments made by the SAT until the company's appeals before the Mexican courts are in process. And the company, First Majestic, states that its interest expenses and management fees deductions that were denied comply with the applicable OECD transfer pricing principles. Now, First Majestic continues to assess all of its legal options, both domestic and international, and including those under NAFTA. It has been receiving assistance from the Canadian Embassy in Mexico and its other diplomatic support. And well, it's the result of that case. It's still out there, and we'll just have to wait and see what happens. And with that, I will turn that back to you, Michael. I completed my presentation.
Thank you, Harili. Much appreciated. Thank you. Thanks to Lauren, and thanks also to Peter for a very engaging presentation. I don't think that at this stage we have received any questions. While we're waiting for any questions, quick reminder now of the 6th CLE code word for US purposes, which is Vancouver, like the city of Vancouver. So that is the code word. Any questions at this stage? We'll wait a few seconds. Okay. So it doesn't seem to be any questions. Peter, Lauren, Harili, thank you so much for this presentation. Much appreciated. And this is the end of our presentation. Thank you.
Thanks, everyone.
Thank you.